How I beat Apple in court without a lawyer. I used to work for Apple. 2 years of retail shifts, Genius Bar chaos, and trying to stay upbeat under that signature Apple smile. I left on good terms before graduation, moved on to full-time work, and honestly thought that chapter of my life was behind me. But sometimes life drags you right back to the Genius Bar, just not in the way you expect. About a year and a half after leaving, I started having problems with both my MacBook and my iPhone. Not minor glitches, actual performance issues that justified repairs. Naturally, I turned to Apple support to schedule a Genius Bar appointment, expecting it to be a quick online booking like the good old days. But nope, Apple had changed things. A lot. They'd quietly made it harder to even get an appointment. Instead of helping customers, the system now seemed designed to filter us out. You had to jump through hoops. Click here, confirm that, wait. For a verification, try a chatbot. Answer irrelevant questions, and then came the final straw. You must reset your Apple ID password to continue. Wait, what? I had already changed my password countless times, practically every few months. This time, I'd only been logged in for about 3 months before they decided that wasn't secure enough. They weren't locking me out of purchases or iCloud, just blocking me from booking a repair appointment. And yes, that's as absurd as it sounds. I wasn't trying to access a bank vault. I was just trying to fix my stuff. After resetting this password over and over for years, I hit my limit. I decided, you know what? This isn't just annoying anymore. This is a company actively making things harder for the people who pay them. I remembered Apple's so-called credo from my training days, something about empathy, ownership, customer-first values, and I realized they weren't living up to their own promises. So I took it up a notch. I filed a complaint with the Better Business Bureau. I laid everything out. How Apple's system was essentially holding my devices hostage unless I jumped through arbitrary security hurdles that had nothing to do with service. Apple's response? A generic, cold-as-ice form letter. For your security, we require password resets periodically. This policy is non-negotiable. Translation? Deal with it. I wasn't expecting a red carpet, but at the very least, a real human reply. What I got instead was worse. Apple considers this matter closed. If you've ever dealt with corporate stonewalling, you know that phrase is the kiss of death. It's how a company tells you that you, as a customer, don't matter anymore. They're done. You can scream into the void all you want. They won't be listening. But they didn't know who they were dealing with. Apple thought they were done with me. They assumed I'd roll over, reset my password like a good little consumer, and carry on. But instead, I started reading. See, when I bought my MacBook and iPhone, I paid for Apple Care Plus. It's Apple's extended warranty and service plan, something I used to sell customers myself. And after digging through the fine print, I noticed something Apple probably hoped no one would catch. Nowhere in the agreement did it say they could deny service just because of a password issue. Sure, there were exclusions, liquid damage, unauthorized repairs, the usual stuff. But nothing, absolutely nothing about having to change your password as a precondition to getting your tech serviced. That was all I needed to know. I filed a case in small claims court asking for the full replacement value of both my laptop and phone. If Apple wouldn't fix them without jumping through unjustified hoops, then they could just pay me for new ones. Now here's where it gets hilarious. Court day arrives. I show up in a full suit, organized, calm, and ready to argue my case. The courtroom's not huge, but formal enough that you want to look like you belong there. My name gets called, I step up to the plaintiff's podium, and then I glance over to the defendant's side and nearly laugh out loud. Apple had sent the store manager from the Apple location I used to work at. Not a lawyer, not a corporate rep, just a manager I used to work with, wearing a t-shirt and jeans, standing awkwardly in front of a judge. To top it off, this wasn't even the closest store to the courthouse. There was another one less than a mile away. Clearly, someone at Apple HQ had skimmed the complaint, seen I used to work at that store, and wrongly assumed this was an employment dispute. Spoiler alert, it was not. The judge looks at me and says, "Explain your case." So I do. I keep it. Short and to the point. I paid for Apple Care Plus. Apple's arbitrary password rule isn't in the contract, and they refuse to service my devices unless I followed this unjustified demand. Therefore, I want the value of the products I couldn't get fixed. Then the judge turns to the store manager and asks, "Are you a lawyer?" The guy says no, and here's the best part. The judge immediately shuts him down. In this state, only an attorney or a registered company agent can represent a corporation in court. Otherwise, they need to remove the case to a higher court and have a lawyer present. The manager stammers, trying to save face, and offers to book me a Genius Bar appointment right then and there. We'll fix the devices. Name a time. Honestly, that was more progress than I'd made in weeks. The judge saw it as a reasonable resolution. He ordered that the case be continued for 2 weeks, giving me time to go to the appointment and see if Apple would actually follow through. Spoiler, they did. But this wasn't the end. Not even close. The appointment actually went smoothly. No tricks, no hassle, no one asking me to change my password. Just clean, professional service. Ironically, the kind I used to deliver back when I worked there. They replaced some components, updated software, and even apologized for the delays. To my surprise, a senior Apple technician emailed me afterward, saying that he had manually overridden the Apple ID policy. I'd never be forced to reset my password again. Honestly, that part felt like a win, but not a complete one. Because while my devices were finally fixed, I was still out $60 in court filing fees. That might not sound like much, but remember, this entire legal mess only happened because Apple refused to provide the service I had already paid for. I shouldn't have had to sue them to get what I was contractually owed. So when the second court date arrived, I went back. Documents in hand, polite but firm. Same store manager showed up, still not a lawyer. And this time, we had a different judge, one who clearly had no time for theatrics. He was slashing through the docket like he had a train to catch. When our case was called, I explained that everything had been resolved with the equipment. But I was still seeking reimbursement for the $60 filing fee since Apple failed to meet their service obligations until I took them to court. The judge nodded, then turned to the manager. Are you a lawyer? No, sir. Same question, same answer. But instead of pushing the issue, the judge just glanced at the clock, sighed, and turned back to me. I assume you don't want to come back here a third time just so they can get a lawyer? I hesitated, thinking this was heading in my favor. I said, no, Your Honor, I'd like to settle it today. Then came the twist. All right, the judge said. Then let's split it. $30 to the plaintiff. Wait, what? That's not how it works. Under state law, if you win a small claims case, the defendant has to cover your filing costs. No ambiguity, no exceptions. But because the judge wanted to move quickly and didn't want to delay the case further, he essentially made up a compromise on the spot. I walked out of the courtroom with half a victory. Yes, I got my devices repaired. Yes, I got some of my filing fee back. But Apple was still skating by on a technicality, and frankly, I didn't like it. I wasn't asking for a fortune, I was asking for fairness. And if Apple thought I was going to give up because of $30, they clearly forgot who they were dealing with. So I reached out, again. I emailed Apple's paralegal. She had been involved earlier, helping schedule the Genius Bar appointment. I cited the exact state statute that guarantees full court fee reimbursement for prevailing parties and politely asked Apple to cover the full $60. I also laid out what would happen if they didn't. I'd appeal the ruling, which would cost them more in the long run, $125 just to respond, and they'd owe me $185 in total. It was the common sense move. Just write the check and be done. But Apple doesn't do common sense. Their response: we'll follow the court's judgment and pay you $30. It was a bold move, assuming I wouldn't go through the trouble of filing a full-blown appeal over $30, and that's when they made their biggest mistake. So I appealed. Most people don't bother over $30. Apple was counting on that. They figured I'd sigh, grumble, maybe post a bad review somewhere and move on. But what they didn't realize was that this wasn't about the money anymore. It was about principle. About a company thinking they could steamroll customers with fine print and form letters and get away with it. The appeal moved my case out of small claims and into circuit court, the highest trial-level court in the county. This wasn't a slapdash docket with rushed judges. This was real court, real procedures, real consequences, and once again, Apple sent the same manager, still no lawyer, still in over his head. This time, the judge was a sharp-dressed guy in a bow tie, with energy, that said he either loved his job or had too much coffee. He greeted everyone with a kind smile, but he didn't miss a single detail. When our case was called, I stepped up, laid out my argument calmly and clearly. I was awarded a partial judgment in small claims court, but according to state law, I was entitled to a full reimbursement of court costs as the prevailing party. Apple refused to pay the full amount. That's why I'm here. The judge turned to the manager. Are you an attorney? The manager, probably expecting this question, by now said no. But this time, he had a letter, a printed note from Apple's chief legal counsel stating that Apple had given him permission to represent the company in court. That went over about as well as you'd expect. The judge's face shifted instantly, from friendly to visibly annoyed. He picked up the letter, glanced at it, and then looked the manager straight in the eye. Let me be very clear, he said. Apple does not decide who gets to appear in my courtroom. I do. And in this courtroom, if you're representing a corporation, you need to be a licensed attorney. End of story. You could feel the air leave the room. Then the judge turned to me. Do you object to continuing this case so the defendant can obtain a lawyer? I didn't even blink. Yes, Your Honor. This is the third time Apple has been told they need legal representation. They've ignored this court's standards repeatedly. I don't believe they deserve another delay. The judge smiled, a big sarcastic grin, then turned back to the manager. With a half shrug and a theatrical hand wave, he said, sorry. And just like that, judgment was entered in my favor. For the full $185 court fees, appeal fees, the works. Finally, it felt like justice. Like I had stood up to the corporate Goliath and walked out of court not just with a ruling, but with vindication. They could have solved this with a single email and a $60 check. Instead, they wasted time, disrespected 3 different judges, and now owed me 3 times that amount. But even then, Apple wasn't finished losing, because when the 30-day payment window passed, they still hadn't paid. At this point, You'd think the story was over. I'd won. Not just morally, but legally. A circuit court judge, the highest in the county, had ruled in my favor. The amount wasn't astronomical, but it was legally binding. Apple owed me $185, and they had 30 days to pay. So I waited and waited. 30 days came and went, and still nothing. No check, no apology, not even a form email acknowledging the judgment. I gave them a few extra days, just in case. Maybe it got lost in the mail. Maybe someone at Apple Legal was on vacation. But when a week passed beyond the deadline, I sent an email to the same paralegal I'd spoken to before. Short, polite, professional. It's been over 30 days. The court judgment still hasn't been paid. What's the delay? The response? We're still exploring our options. Exploring your options? There were no options left. Apple had already lost. There was no appeal. The case was closed. The judgment was final. They owed me $185 and were pretending like the rule book didn't apply to them, that they were somehow above the court's authority, and that was the last straw. What Apple didn't know, what they forgot, was that I used to work for them. I knew their systems. I knew their payroll structure. And most importantly, I had records. So I did what they never expected. I contacted my credit union and pulled an old pay stub from my time as an employee. On it was a direct deposit transaction. One that clearly showed where my paycheck had come from. The bank name, Wachovia. That was all I needed. Armed with this information, I went back to court, again, and filed garnishment proceedings. Because I already had the banking information from my old employment records, I didn't even have to go through the normal discovery phase. No delays. No red tape. The court approved the garnishment. Paperwork was sent. And within days, Wachovia cut me a check. Paid in full. It was over. Apple, the tech giant worth billions, had been legally forced to hand me $185, not because I shouted the loudest or had the fanciest lawyer, but because I understood one basic truth. They don't get to ignore the rules. Just because they're Apple, they thought I'd give up, that I wouldn't go through the effort, that I didn't matter. They were wrong on all three.
The case has been heard. The stories have been told. Now it's your turn to judge. Leave your verdict in the comments. Like, share, and subscribe. The Court of Stories is always in session.